Okay. Welcome to the Ad Hoc Commission on the Discipline System ENEC Working Group. We are live, and looks like we do have a couple of attendees that are internal staff. Just to let the attendees know that we are currently waiting. We don't quite have a quorum yet, but we anticipate another committee member to join us shortly, and we will begin the meeting at that time.
Justin, I don't think anybody has an inherent need to see me, but in case you're expecting me to turn my camera on, it says that I can't because the host has stopped it. I'm sure people would be happier without seeing me, but.
Not true.
Mine, it's a similar situation.
So am I.
Well, I'm glad to know he didn't just stop mine.
No, not. You're not being picked on, Steve. Good morning, Leah.
Morning.
Good morning. It says I can't put my video on.
Same here.
Oh, okay. Well, that's good. It's a little early, so that's fine. We can just see you, Justin.
I'm trying to make everybody a co-host to allow them to put their cameras on.
Yeah.
And Linda, Leah, we're waiting for Ed to join, so we have the third member of this committee. Melanie is not going to be here, but Ed should be joining momentarily, and then we'll start on the presentation.
Okay. And I have to jump off at 8:30. How is everybody today? I'm glad the governor survived the recall.
Nice to have that done.
Yeah.
My attempts to make everybody eligible to turn on their camera, I made you the host. Is there a way you could make me the host again? I took away.
Me?
Steve.
Oh.
Sure.
I made you the host, and so if you could make me the host again, I didn't mean to do that.
Will my camera turn off? I'm sure that. Okay, I'll make you the host if maybe you could make me a co-host. Maybe I'm still a co-host. I don't know.
Are you sure Ed is joining, Justin?
Got an email this morning that he was going to be 15 minutes late.
Oh,
And I wasn't sure if we could take public comment, but there is no public attending. So before I called the meeting officially, where we had a quorum. And there's Ed. Good morning. All right, I will now take the roll. Judge Wang,
Good morning.
Linda Schneider,
Yes, I'm here. Thank you.
okay, Edward Lear,
Here, sorry that I'm late.
okay. Melanie Lawrence. All right, we have a quorum. I will now call for public comment if there's anybody in the public, which there does not appear to be anybody in the public in the attendees list, so we can move on to the presentation. Ron B. is here from our Office of Research and Institutional Accountability, and he is going to provide an update on the ENEC process with regards to the criminal conviction. And so, Ron, I will turn it over to you.
Okay. Let me share my screen. Can everyone see the slide?
Yes.
Yes.
Like Justin said, the primary purpose of the presentation, the focus here is on a couple issues. One is criminal conviction cases. And for criminal conviction, we'll look at the trend and the outcome, and then the timeline in terms of from beginning to end, the entire process, the case age at different stages. And lastly, just to present an overall flow of the ENEC process, to look at cases going through the entire process and identify the area where it'll be most productive to look at certain kind of outcomes in order to have an understanding about the efficacy of ENEC. So that's more clarifying the research questions and to identify what cases to look at and what's the outcome variables to look at. A little bit of background related to criminal conviction cases, primarily because in the past couple of years, instead of the regular kind of a criminal conviction cases that typically come from multiple referral sources like the court, prosecuting office, or self-reporting, we had fingerprinting project that started back in 2018, and then working with the DOJ, that's the source of what we call CORI cases, Criminal Offender Records Information System, where we have the rep sheets of all of the licensed attorneys, and the criminal records becomes the CORI cases. And that's where the involvement of the ORIA office to review the cases and then transfer those cases, creating a record, creating a new case in OCTC. And that's where OCTC process starts to review these CORI cases. So the trend, the outcome, everything in the past couple of years about criminal conviction cases is affected disproportionately by these CORI cases. In the next few slides, I'll give you some overall picture about the trend, the outcome, the difference between CORI and non-CORI cases. And also a key point about the process for all criminal conviction cases in the context of discussing the potential of benefit of the ENEC is a 30-day requirements. As soon as a certified copy of conviction records is obtained from the court, usually, then that case needs to be transmitted to the state bar court. So that's the time constraint in the statute. Here's a picture of the overall criminal conviction cases in the past few years. And you see a clear, dramatic jump from in the past, it's about 250 cases per year, criminal conviction being the source. And from the second quarter of 2019, overall, for the full year, the amount of these criminal conviction cases increased by 10-fold. Instead of about 200 cases in both 2019 and 2020, per year, we have more than 2,000 cases. And based on the recent trend in the past couple quarters, it appears that we have begun to just work through all of these backlog of Corey cases, and then we'll expect the trend to go down in the next few quarters and certainly a year or two.
Ron, can I just interrupt for 1 second?
Sure.
Going back to that other slide, I just want to highlight that this chart that you see is cases opened, not the inventory. And so when you see Ron, when you hear Ron say that the criminal conviction cases fluctuated around 250 and the initial part of that graph is much lower than where 250 is, that's because those are just the cases that are opened.
Thanks for clarification. Incoming, outgoing, and the pending caseload, the relationship is always a little difficult to sort out. The next few slides are comparisons of outcomes of criminal conviction cases. A comparison also within the discipline outcome between the traditional criminal conviction and Corey cases later on. Here is private conviction, private reproval and public reproval. At the beginning of this period, private reproval cases involving criminal cases represent 11% of the total. At the end, last year, it accounted for 43% of the total. So that's the contribution of the Corey cases for overall discipline in private reproval. And public reproval, the increase of criminal conviction cases as a proportion of the total increased much more than in private reproval, starting from 25% of the total to almost 80% last year. Now looking at probation, it was a slight increase proportionally that could be attributed to criminal conviction cases. Initially, at the beginning of the period, a 16% increased to close to 30%. Similar trend in terms of the proportion of criminal cases as a percentage of the disbarment. Initially, about 10% increased to 25%. All of these is because the increased number of criminal conviction cases as a whole, a large part because of the Corey and fingerprinting project. Here's a breakdown of all of the discipline outcomes and looking at the percentages with a focus on reprovals, as that was the intent to look at the relationship or the connection, possible connection between criminal conviction and considering ENEC process as for reprovals with the being possible outcome. At the beginning of the period, you have about 17% of the disciplines that resulted in either private or public reproval. Last year, the proportion of reprovals, including both private and public, increased to more than 30, close to 40%, 39% to be exact. Disbarment and probation, the other two major categories, fluctuated over the time period, ranging from 25% to 50%. So the largest proportion that fluctuated during this period is attributed to private and public reprovals. And that we saw earlier is a result of increased number of criminal convictions cases in reproval. Moving from outcome of the cases to time from beginning of the process. Initially, the beginning of the process, criminal conviction cases, the intent was to track the offense date until the different events later on. When we looked at the data, offense date is not readily available, but instead we use the conviction date. Conviction date in the criminal conviction records, that's more readily available. And then also in Odyssey, we're able to pull the data. So that is a proxy. The case age was calculated with conviction date as the starting point. And then we track them at two different points in the process. One is from conviction date to transmittal. The other is from conviction date to final disposition at the state bar court. So this analysis does not include cases closed in OCTC without being transmitted to state bar court. The first chart shows the time from conviction to transmittal, and the comparison is between Corey and non-Corey cases. You can see here 80% of non-Corey cases took less than 2 years, compared to barely about 20% for Corey cases. And also for Corey cases, more than half of them had more than 6 years elapsed from the beginning of conviction to transmittal to state bar court. And case age, when compared at final closure, had similar patterns in the difference between Corey and non-Corey cases. So you can see non-Corey cases from beginning to end, more than 60% of the cases resolved within less than 2 years. For that same period, it's less than 20% for Corey cases. So overall, this is an indication of Corey cases. The original criminal offense occurred much earlier than the traditional non-Corey cases.
Ron, can I add something?
Sure.
So I don't know if this accounts for it, if Oriya broke down the lag between the review department and the hearing department. So just to educate everyone. So once, Ron pointed out the statute that requires OCTC within 30 days to transmit it to the state bar court, it gets transmitted to the review department. And so the review department goes back and forth in terms of requiring from OCTC evidence of finality. So just because OCTC is made aware of the conviction, it does not mean that it's ready for processing in the state bar court end. So that can be a reason why we're seeing this lag here on this chart. So once the review department of the state bar court has everything it needs in terms of finality of the conviction, that's when it gets transmitted to the hearing department. And once it gets to the hearing department, we have 125 days to start the trial. So I just wanted to throw that out there so that this data is not misinterpreted.
Thanks, Judge Wong. So to further clarify, the charts here in terms of the aging does not reflect the time from transmittal to final closure within the state bar court part of the process. When we look at it, we see a large percent of the cases closed within 1 year, and a lot of it is because of summary disbarment process.
I think that what Judge Wang said is important, and what Ron just said is important too. I think that one of the main contributing factors for the Corey cases taking longer is actually the time between conviction and when the state bar learned of the conviction, as opposed to anything else. When we find out about it through non-Corey purposes, and I should say for Corey purposes for this discussion, I'm primarily referring to fingerprinting of attorneys that revealed prior convictions, as opposed to subsequent arrest notifications, which come in relatively promptly, or at least I think they do compared to the others. But when we learn about them through non-Corey avenues, it's generally the court reporting, the superior court in the counties where the conviction occurred reporting, or the attorneys reporting the conviction themselves, and they do it relatively promptly when they do it. It's generally a question of whether they do it or not, which is how we then learn about things through the re-fingerprinting process, where we learned about crimes that were significantly older as far as the conviction went. Hopefully that made sense.
So with these, I conclude my presentation about the two aspects of a criminal conviction cases, outcomes and the timeline. And the next one slide.
Ron, I have a question.
Sure.
If you wouldn't mind going back to your last slide. Okay, there we are. Okay.
Oh,
So,
here.
yeah, right there. So just a basic conclusion about what we're seeing here. The Corey cases take longer than other cases, right? That's kind of the bottom line that we're seeing.
Taking longer, not referring to the part of the process after we learn about it. The longer time frame is largely because by the time we learn about it, the original offense is something that occurred 5-10 years ago. Relative to the traditional non-Corey cases, the time frame from conviction to when we learn it is relatively short. And
Okay.
this is entirely because of the fingerprinting project, learning about the crimes that occurred many years ago, including I've seen like 30-40 years ago.
Do you have any data on how long Corey cases were taking before the fingerprinting requirement was instituted?
We didn't have Corey cases then because we were not getting reports, either prior reports or prior convictions or subsequent arrest notifications before the Corey project started. I don't think that, I think the non-Corey cases are probably a good representative, Ron, correct me if I'm wrong, of how criminal conviction cases moved through the system prior to Corey as well. The non-Corey may have slowed down just because of the caseload that has impacted our office, but generally I think that's probably consistent.
I see. So the 2018 change is a huge change because now the state bar is getting all of these convictions that it never had before.
Correct.
Okay, so there's going to be a hump that we go over, right? And then it's going to clear. And then once that clears, the state bar will be receiving conviction information that's much more fresh on when the conviction occurred.
Yes, I think we will still be receiving more of it. So I think the hump, the tail end of the hump will never go back to where it was at the start, but it should come back down to something hopefully more manageable. Yes.
Okay, thanks very much.
So as I mentioned, this is more for clarification of the entire process so that when we pull the data, we know what's part of the process that we need to gather more detailed information to track the outcome. So this is a flow chart of the entire case flow from beginning when the ENEC notice was sent out at the upper left corner here, that's the starting point. And then depending on whether the respondent respond to that notice, you have one path going down the ENEC process represented by the orange boxes here. So when they respond, you have ENEC scheduled. When after it's scheduled, the respondents and the parties may or may not participate. And for those who participated, you have the outcome of settled or not settled right out of ENEC. But even after the ENEC outcome, indicating whether it's settled or not settled, shortly after, you may have cases reaching pre-filing stipulation. I've seen those cases where maybe after a couple of days, after initial ENEC didn't result directly into settlement, stipulation occurred. So that's the part of the process for cases going through the ENEC process. When we talk about ENEC, within the context of all of the other cases that go to final disposition without passing through this path, I wonder whether that's also part of the evaluation. For example, if in a year you have 100 cases going through this entire process, In 1 year, you have maybe 20 cases participating, responding to the ENEC notice. And then the settlement rate calculation will be based on those 20 cases. In another year, or in a different situation, you have 40 cases going through the ENEC process. The case composition and characteristics might be very different. And when you look at the settlement out of those 40 cases, I'm not sure that's comparable to the 20 cases that went through the process. So the question of the overall efficacy of ENEC has to take into consideration of the cases that went through this particular process in comparison to the cases that didn't. So that's a question about how comprehensive we want to understand all of the cases going through the process with a focus on ENEC. That would have an impact about the cases that we collect, the detailed data. Initially, we were thinking about the sample of cases that we used to analyze the more interpretive cases. That's 442 cases that's closed, reaching final disposition in the past couple of years. We can look at all of them and then see what's the proportion and the number of cases going through the ENEC and identifying those to see what's the outcome directly out of ENEC. But that has an issue in itself because those 442 cases, for many of them, ENEC occurred several years back prior to Odyssey in system was implemented. And in the legacy system, outcome of ENEC process, that information is not readily available. So the only way we could look at ENEC case outcome for those 442 are ENEC processes that occurred after Odyssey. And by the mere fact of these cases where the ENEC occurred more recently, those cases might be very different than the ENEC out of the same 442 sample that occurred prior. So this is just a caveat about the sample of the cases. We have the information and the possibility of some bias the outcome simply because the characteristics of the cases are different. Or we can take a different approach. Regardless of whether they belong to this 442 complete set of cases, we look at all of the ENEC cases that took place in the past couple of years since Odyssey. Even though they may not have reached the final disposition, that's another way of looking at direct outcome of ENEC. And for that, we can readily pull out all of the cases to look at it. At the end, I think we will probably look at all of them, different combination of cases, except when we interpret the results to have a determination about the degree of the efficacy of ENEC, we need to understand in different contexts, the interpretation would have to take into consideration the case characteristics that will affect the outcome. With that consensus, then we'll begin to compile data to present as comprehensive a picture as possible with an understanding of the data limitations. Any questions about this part of the ENEC rather complicated process?
So are you looking for confirmation from the working group, Ron, on your process there?
Not so much confirmation, but feedback about the different ways of looking at the question of ENEC efficacy, any input about different approaches, different focuses. Or maybe we don't know until we have the data identifying different part of the process and see what the data says about the outcome.
Ron, I have some comments. Can you go back to your slide with the trends? It was one of the first.
Right. Can I just make a suggestion? Let's thank you. I think we should just field all questions with regards to the criminal conviction analysis before, and then we'll turn our direction to the issue of like, how do we study the ENEC process in general? So go ahead, Ed, take your question. We'll take your questions.
Thank you, Ron, for your very informative presentation. I found this one particularly interesting, and I think Steve was speaking to this as well, which is to say that in that first quarter 19 through about first quarter 21, I look at that as being aberrational. And I think Steve was speaking to the fact that the trend line we saw from Q1 15 through Q1 19 will be increased or higher on a going forward basis. That's the tail that he was speaking of. And so this is really informative. And for those of us that are practicing in the state bar court, I think that this is pretty consistent with the experience that we've had, which is the incredible spike in these Corey cases that we've seen over the course of the last 2 years. And it appears that is now abating to a degree. Ron, can you turn to the next slide? This one I thought was very informative too, in one particular way. And that is looking at the top graph where it indicates that private approvals involving criminal cases represented 11% in 2015. I don't, again, back to the spike up to 43%, that is interesting to me, but not so indicative of the problem that we are trying to resolve. What I found interesting is that 11% is a reasonably high enough number for us to be doing what we're doing. And by that, I mean that criminal conviction referrals that end up in private approvals that end up ultimately being public constitute 11%. That's my sweet spot, so to speak, to judge whether this is a worthwhile endeavor or not. If hypothetically that number had been 1 or 2%, then I would have been surprised, but this would have been a lot less worthwhile. Where in fact it's 11%, I think it makes it a very worthwhile project in order to try to create a situation where we have potentially 11% of cases that are now public with respect to criminal conviction referrals, have them be non-public. And so I thought that slide was very informative as well. What I didn't see, Ron, is, and you can drop the slide, is any with respect to the efficacy of an ENEC process. So in other words, when matters go through the ENEC process, how likely are they to settle at that point versus not, and whether we're breaking that down by substantive areas or not, and or whether you and your team even have the ability to make an assessment that way. And maybe that's the second half of the presentation, I don't know, but that would be very interesting to me. And again, I think it's challenging, but is that something that you think that your team would have the capacity to figure out?
Yes, that is the intent. But before we pull the data, which we have already done some, the purpose of this slide is to clarify the scope of the analysis and understanding whatever we focus our analysis, the inherent limitation and interpretation of the results based on whatever data we have available for the cases.
I would just add, going back to I guess, slide 5, Ron, I certainly understand Ed's concern about the 11%, particularly when you look at it in terms of an otherwise private approval is essentially public because it has been transmitted. Although when you look at it in terms of raw numbers, Ron, I guess I'm wondering if this is correct. Or are we looking at, 3 people per year?
Yeah, that's
where
about
this occurs?
right.
I think we need to keep that number in perspective too when we start thinking about the impact on all of the other cases that are criminal conviction cases that may be then sent through an ENEC, particularly in light of the fact that OCTC is obligated to transmit those within a certain time frame, and how feasible that is. I'm not suggesting that we shouldn't do that or that we should, but I think we need to keep both of those considerations in mind.
I'd like to offer one other observation along the same lines, and it's interesting to know that we're only talking about 3 cases there. But that observation is that since the State Bar started receiving those criminal conviction records on a regular basis and has a huge, really backlog of old criminal cases that it's receiving, that's going to be reflected, I think, in those private reprovals, because if you have a very, very old case, the State Bar is going to likely look at it differently than a conviction that is very fresh. So I think you're probably going to see a lot more. I think that's probably why you see a lot more private reprovals or even public reprovals than you did in the past. I think a better viewpoint on it would be looking farther back at the number of reprovals that were received rather than the spike that has been evident since 2018.
And I'd like to add to Ed and Steve's point. I know if we're looking at the raw number of 3, it doesn't seem like a lot, but I also want to point out that what's not captured here are the dismissals. So I have had quite a few older convictions that get filed because OCTC is required to do that, but then it ends up in dismissal because of proof issues and the age of the case. So this is a little bit, it depends on what your question is. So this data might be answering a different question depending on what your question is. So my point in that is when we're looking at the overall numbers of the court, at least from my perspective, and the data point, that those dismissals may, in my view, maybe they should never been filed. So at an ENEC level, that might have been shaken out. OCTC and the court at that point, the court may have been able to point out some proof issues and the matter resolved at an ENEC phase on these older cases. So I don't think we can look at the raw number of 3 and say we should not have ENECs. So that's one point. And the other point, kind of advocating a little bit for Mr. Lear here, but in terms of the public reprovals, at least from my experience, as we're negotiating it, one of the issues is OCTC will argue, well, it's going to be a private reproval with public disclosure anyway. So why don't we settle this for a public reproval, since it really doesn't have that much effect on the respondent. So some of those public reproval cases may be appropriately resolved as a private reproval, but then the respondent kind of gives in at that point because there isn't a mechanism to do a truly private reproval. So before we throw out the baby with the bathwater and say we shouldn't do ENECs for conviction cases, I don't think we should be looking at the raw total of 3 cases.
Let me just add to that, and thank you, Judge Wang, because I forgot about the dismissals. And so my office had a lot of these Corey cases, and probably in the last year and a half, we've had 15 dismissals or so. To put that in perspective, in my over 25 years State Bar defense practice, I probably cumulatively had 5 prior to that. So that's a lot of dismissals, and all of those dismissals were after the referrals. So they were all public matters and all matters that were going through the litigation system. I agree with Judge Wang that probably the vast majority of those 15 could have been negotiated as dismissals in an ENEC process, which would have ultimately had the same effect for my clients, but for the fact that they went through the litigation process where their matter was public through the State Bar Court website or membership record. And also they then had to spend monies on legal counsel, me, in order to get through the process. So those are matters that I think would have benefited greatly. through the ENEC process, and I'm still advocating for that. But I advocate with kind of this qualification of I too understand the metrics, which is the period that we've seen in the last year and a half is not likely to be replicated anytime in the near future because of the way the Corey system was set up. So thank you.
Yeah, I want to recognize that what Judge Wang and what Ed Lear is saying is correct. I mean, there are more dismissals. We recognize it. I guess that from our perspective, the issue is that likely to continue? And I would invite both of you to correct me if I'm wrong. But my understanding of those dismissals, they tend to be the cases that are transmitted as moral turpitude based on the facts and circumstances, or potentially just other conduct warranting discipline. They are transmitted initially because the crimes for which the person is convicted are significant enough that under normal circumstances, they would be transmitted as such. But the problem is that in this case, they are very old. And so we have trouble getting those police reports to establish what those facts and circumstances are, to then be able to prove the facts and circumstances at trial. Part of the issue there is that we don't have enough time prior to the requirement that we transmit to get those police reports. Once we get the court records, we go back to try and find out, that the conviction is final. We go back to then get police reports. And because they're 5, 10, 12, 20, 30 years old, we can't get those records, but we don't know that until after we have transmitted them, which we're required to do by statute. And so that ends up being the evidentiary issue to which you both have referred, and I readily concede is absolutely right. But I don't know that we have an option of not transmitting them, at least under current law, of not transmitting them, nor do we know that we're going to have that evidentiary issue until later on. But the point that both of you raised is absolutely correct.
Well, and that's sort of my point too, is do you want to change a system based upon, a situation that is aberrational? You have this glut of cases, they're very old, and that's affecting the data, and that's understood. But do you change the system based upon that? That's what I wonder.
And my quick response to that, Linda, is that I haven't yet heard of a downside for changing the system in this regard, even if it's only 3 respondents that are impacted by having private approvals with public disclosure. That to me is worthwhile. I'd love to hear a counter to that, but I just haven't.
Well, I'm curious, what is the cost? Because, what I don't think we know yet, maybe we'll find out today, is, how much time does the ENEC add on? The state bar is under, obvious scrutiny to be able to process all of their cases through that backlog point, that is reported all of the time. So, how much time does it add on to the entire system when every single criminal case has that opportunity for the ENEC? So maybe we'll find that out more of that today.
No, we haven't, if you're referring to the data related to ENEC outcome, we haven't gathered the data to do that analysis and comparison yet. Yeah.
Okay. But I think that's what you would kind of have to balance, is how much time are you adding on overall to how much benefit there is for a few people.
And this really gets to the inherent difficulty of making this comparison. When you say that how much time adding to it, you are referring to a counterfactual of cases that could have gone to ENEC but didn't. And if they didn't, it's not so much because we have a random assignment of cases, one group to ENEC, the others didn't, so that we can confidently compare the difference in the time between the two groups' cases. ENEC cases went into ENEC because they have certain characteristics. So it's a self-selection. From a research point of view, it's very difficult to say with confidence the time difference that you saw truly could be attributed to ENEC, but we'll try it and see. This is just before we get the data, a caveat about the interpretation.
Okay.
Ron, is there further presentation or was that,
That's it.
that's it?
Yes.
Okay, so does anybody else have any questions or requests on the follow-up from this? It looks like we had a thorough discussion on this, and I know that Ron still has some research to do with the data. I don't see anybody raising anything, so I think if nobody has any other questions or anything to discuss, I think we are done for today. I appreciate everybody coming to the meeting, and we will have more information soon.
Thank you, Ron.
Very
All
good.
right. Thank you.
Thanks, Rob.
Thanks,
Thank you for
everybody.
the
Bye.
presentation. Very helpful.